What is the impact of domestic violence on child custody orders? Under California Family Code 3044, there is a presumption against awarding custody to the perpetrator of domestic violence. Now, this particularly comes into play where there has been a criminal conviction of domestic violence. Now, this is considered to be a rebuttable presumption, which means that even if somebody has been convicted, they may be able to show the courts it's in the best interest of the child for them to share custody or have visitation with the child. However, certain factors need to be looked at. They're going to need to show that if alcohol was involved or drugs, that they've enrolled in some course of treatment or they've attended their batterers prevention classes. They'll also need to show that it's in the best interest of the children to have that custodial time. When initially filing a domestic violence restraining order, often a parent will want to seek custody orders during the initial filing. So at the time that the temporary restraining orders are granted up until the trial, one parent may have no visitation of the children. We want to make sure that the health, safety, and welfare of the children has been protected. So it's important to produce actual evidence at the trial so that you can keep your children safe and keep those restraining orders. Now, what happens with false convictions or where somebody's pled no contest to a domestic violence restraining order? If you have been falsely accused, oftentimes there's a desire to settle so that you don't need to go to criminal court, but you should really speak to a family law attorney in addition to your criminal law attorney and coordinate together, as there may be a presumption about you being able to have unsupervised time with the children based on a no contest plea. That is determined to be a valid conviction for purposes of child custody determinations. So looking at what you're actually pleading guilty to is going to be very important. So you want to make sure that you understand exactly how that's going to relate to custody in your case. I had a case years ago where the victim of domestic violence was actually falsely accused by her spouse, and she was arrested and spent the night in jail. Well, she was unemployed and had been a stay-at-home mom, so the husband did not post bail. She was sitting in jail and wanted to go ahead and work out a plea so that she could get out of jail and get back home. Well, she soon learned that she was unable to have custody of her child and had supervised visits, and the child was actually left in the hands of the abuser. Fortunately, we were able to prove to the court with credible evidence that it was in the best interest of the child to be with the mother. We're also able to prove that actually, had she not pled guilty and had she had informed counsel, the case would have likely been dismissed for self-defense purposes. So make sure that you're consulting with the appropriate attorneys. If you have any questions, just shoot us over an email or give us a call so that you're not negatively impacted and your children are kept safe in cases of abuse.